Student Loan Scheme Amendment Bill number 3 unreservedly and commend it to the House. Thank you.
Tracy Martin.
Kia ora, Mr Speaker. I rise to oppose this bill on behalf of New Zealand First. New Zealand First is of the view that such measures as arresting your own citizens at the border are Dickensian and are entirely disproportionate to the nature of the offence. And it's somewhat poetic that we use that word Dickensian, as it is a documented fact that Charles Dickens was forced at 12 years old to leave school and to take up factory work after his father was thrown in a debtor's prison in 1824. And it seems fantastical that we are reinforcing the concept of debtors being arrested and brought before the courts 190 years later, and it somehow seems worse when this is the considered punishment for a debt that was incurred to gain education. Now, we also believe that measures in this bill must be viewed in a wider context. Finance company directors virtually stole billions of dollars in recent years and ruined the lives of many people, yet in many cases avoided prosecution or serious penalty. The student loan scheme has already had many unintended adverse consequences, and this bill will create more. We urge the government to reconsider the excessive measures proposed in this bill. New Zealand First believes that other measures must be explored to create real incentives for repayment. The real solution to student debt issues is ensuring that there are decent paying jobs for students to go to after they graduate so that they can repay their loans without having to go to Australia or anywhere else. In New Zealand First's view, making a group of young New Zealanders outcasts from their country is not a solution to the problem of outstanding student debt. We believe that Section 16B, which allows the District Court to issue an arrest warrant if it was satisfied that a person who had committed this offence was about to leave New Zealand, is placing an ambulance, or actually in reality it's a police car, at the bottom of the cliff. It would make far more sense to New Zealand First that as that passport holder, as that citizen comes back into New Zealand, that an Inland Revenue officer is placed inside the international airport and therefore makes contact with that person on their way into this country and collects the information that is being required. Why would one stop a person on their way out of the country when there is now no opportunity for them to either produce a third party, to spend time with the paperwork, etc., and one expects them to have $30,000, $40,000 shoved in their back pocket? If you want to make contact with these people and you have the process of cross-matching and matching information, then find these citizens on their way into the country and have the conversation there. Don't wait for them to be on their way out of the country. It seems ridiculous to us. And with regard to the committee report, so in the committee report it says, under these sections as amended, the court could order the borrower to pay the amount in default, to enter an arrangement to do so, or to provide information to the court. We would envisage the court requesting such information as the borrower's contact details or information about their assets, income and employment status. And again we say, sir, that seems much more sensible to us to actually seek that information as the citizen is entering the country, rather than wait until they are on their way out. Because we also note that it says in the report, we also recommend inserting new section 162B7 to make it clear that a court would be required to direct the return of any travel documents or tickets once it discharged an order not to leave New Zealand. It seems nonsensical to us, just completely impractical. If you've got somebody at the airport about to board a plane and you stop them, their tickets, there's no point giving them their tickets back after the plane has left. Is there any compensation to the individual if they are stopped at the border, their plane has left, their $2,000 worth of tickets, and they've now come to an arrangement? What plane do they get on? Is the government going to compensate? Whereas if you talk to the citizen on their way into the country, then arrangements can be made and that situation is avoided. And I want to take up the point of, the somewhat rosy view of the Inland Revenue Department. My husband had a student loan. My husband cleared his student loan when he went to work. However, the recording of that payment was not processed appropriately. So, sometime in the future, we received, after years of receiving a zero balance statement, we received a statement for so many thousands and had to go through the process of proving through our bank records that we had paid that amount. What will happen if, say, my husband was arrested at the border but had already paid that account? How long would it take for him? Does he have to go to court to prove it? And does he have to have all his bank account records on him if there has been an error made? If there has been an error made by the Inland Revenue Department, what is the compensation available if they are mistaken? How does that citizen who's now been pulled out of a lineup and arrested at the border, how are they recompensed by their government if it is an error from the Inland Revenue Department? So let's just put some practicality around this. I think the other thing too that we want to point out, sir, is it's a little point that nobody's mentioned yet. It's on page 4 of the report. The bill recommends altering the definition of adjusted net income for student loan repayment purposes to reflect provisions in the Taxation, Livestock Valuation, Assets Expenditure and Remedial Matters Act 2013, requiring employees who receive certain non-cash benefits from their employer, such as a motor vehicle, to include them in their income calculations. Now, I just had a quick look. I think that this has been included in the bill because once again we have this bias this biased view that everybody who has a student loan is somehow a doctor or a lawyer or some highfalutin individual that has a mega income and then they get all these add-ons on the side. I had a look at, for example, a biosecurity officer. Now, there's a need to get a student loan to go and actually then be qualified enough to become a biosecurity officer. A biosecurity officer in the first 3 years of employment can get between $35,000 and $45,000 in salary. And often they get a vehicle that goes with that because they have to travel around to look for Argentinian ants on Kowau Island or whatever. What we're saying now is, with that amendment, that their car is now going to be included inside the concept of their salary, which means that the amount that they are supposed to repay can take them into a higher threshold. Now, it hasn't been mentioned before, and I think it is something that needs to be looked at. I'm not quite sure whether the true practicalities of that measure has been thought all the way through to when it actually hits the ground. I want to refer now to Treasury's notes, which I'm trying to find where the government actually got this from and where it thinks it's got support from, and I can only imagine it has support from a very few of its own constituents that somehow believe what they tell us, that this will work and that these people are bludgers. The Treasury notes say this proposal may have the appearance of police acting as debt collecting agents for the Inland Revenue, which would be completely inappropriate. The police have another role. We already have difficulty with the way they are viewed by many in our society. We don't want to chip away at the way they are viewed anymore. It has been additionally noted by officials that they do not expect the threat of arrest warrant to be particularly effective, and a particularly effective incentive. Inland Revenue's new allowance to identify those for whom they believe an arrest warrant needs to be applied has been defined as punitive and unprincipled by the Legislation Advisory Committee. So you've got Treasury, you've got the police, you've got the Legislation Advisory Committee, you've got the regulatory impact saying that this creates an inequity whereby two loan borrowers of the same loan balances may have a different repayment obligations. You've got the impact of this policy on compliance of overseas borrowers is uncertain. Officials have also stated they do not expect faster recovery. Sir, there's not a single official in these documents that truly stands behind this decision. There is another reason for this. It isn't about collecting debt. It isn't about the practicalities of how this will work, and it isn't about helping New Zealand citizens, but it is possibly about putting in place the ability to arrest your citizen at the border with debt so that later on that statute sits there and can be used for another purpose.
Honourable Kate Wilkinson.
Thank you, Mr. Speaker. I rise to take a short call